Isn't that something?
Right, but the difference, Justice Cordy, is the locked door in the bedroom in terms of, and again, look at Nielsen, is are you going to waive your constitutional rights for the government to come in? And under these facts, you know, my client and his mother were living there for over 7 months at this point. The expected stay was 4 to 6 months. The policy talked about
the brief says 4 to 8.
4 to 8, excuse me. But they were in their 7th month at this point, and
don't they run the risk that the manager, who has all of this authority and control, including dictating where they will stay in the house, they could be moved from room to room, don't they assume the same kind of risk that that person might consent to a search from outside authorities? But
Ms. Brown in the shelter, they're not cohabitants. They're not living with them in the room in terms of...
I understand that. Well, yeah, but you would have to say that the executive director has much more control over the space than the person who happens to be living there under the restrictions, under the contract.
I take it you are asking us to say in the Nielsen case, the dormitory case, the student had signed a contract as
Correct.
a condition of being in the dormitory room that permitted not only just the director but staff members to enter the rooms at any time to inspect for precisely the same reasons: health, security, those kinds of things. And in the Fitchburg case, the resident, tutor, whatever it was there. The police were there. They found the drugs, and the court said, no, you can't do that, because what the student did was agree with the university, with the resident, that they could come in, but didn't agree that the police could come in, right?
Correct, Justice Marshall. And if you were not to agree with my argument in my brief, you'd essentially either be reversing that case, or as in the 2 different amicus briefs filed by multiple parties, what you'd be doing is essentially creating 2 classes where somebody who is told we can search your room any time in your dorm room, and they hear the sound of a cat, and they're allowed to go in and search your whole dorm room, and you know that.
You have given them the right to invite the police in.
Correct.
And
in the court in that case.
It's a different situation. In Nielsen, for instance, the student was paying for it. It's not a different constitutional. It's not applying the Fourth Amendment differently. It's the situation that's different.
Justice
In Nielsen, the student had a significantly more control over his room. He could move the furniture around in his room. I mean, the fact that these tenants they're not even tenants, but these people in the room could not even move the furniture around in the room significantly limits their freedom in that room.
The difference there, Justice Cowan, and I want to get to the issue of paying money. Are you saying that if that young man had a scholarship that the state paid for him to stay in the room, therefore he doesn't have privacy?
No,
I
am saying that the rights he had in the room were so much more than what these people had in the room.
Right, because
they couldn't have food in the room. The student can have food in his or her room. Because they couldn't have guests in the room. The students have guests in their room. Sometimes they sleep overnight all the time.
The reality is that when you're homeless and you qualify for this benefit, there are obviously limited funds. And we can't pay for you to have your own apartment. That's why you're in a temporary shelter. You have to try to get that on your own. Obviously, a college student expects a little more freedom, and that's why they have the freedom.
What do you say to the finish your answer.
Just where do you draw the line? Do you say, therefore, you have no privacy rights because we're putting you in an...
You don't have an expectation of privacy given these circumstances. And you can't keep over $100 of valuables in your room. I mean, the limits are so extreme in this case.
Right.
And I'd like to ask you, because it isn't clear from the brief, can the occupant be ejected by the management?
They can, and there's several. If you violate certain rules, you can be ejected. If you violate the DTA rules in terms of your benefits run out, you can be ejected.
I mean, for a gun, you can be ejected immediately. You're required to be ejected immediately, right, for a gun?
Correct.
Yeah. What do you say to the apparent authority argument that the Commonwealth makes?
Well, the apparent authority, I think, is basically like the train has left the station. I'm asking you to put the brakes on this in terms of there's really no limit. And I argue a dissent from Justice Thurgood Marshall in Illinois versus Rodriguez, which I'm asking you to look at Article 14 and put some control on the apparent authority. Apparent authority here, Detective McLaughlin spent quite an amount of time thinking this through. And Judge Harris, in his findings and in terms of what he said on the record, did not credit that this was reasonable because he had so much time and he made the wrong decision, in my opinion, in Judge Harris's decision. And what he could have done was gotten the warrant. And what I cross-examined him, and it's clear on the record, I put it in my brief, of what he said was, we really weren't looking for consent. I really didn't want to inconvenience the families. I'd have to lock the place down, and we wanted to do this quietly, and I wanted to give your client a chance to be summoned in and not arrest. And he went forward. And Justice Marshall says that if you do that...
I believe he said, I thought I was helping her.
Right.
I thought my job was simply to aid her in getting that gun.
Yeah, but that I think, Justice Gantz, is his way of, sort of saying that, well, I'm not really the state actor here. I'm really helping her do a private search. And clearly it's a government search. And once he gets to that point, it becomes a government search and the Fourth Amendment applies.
But is there some inherent contradiction in your beginning your argument by saying this is a matter of first impression, not only for this court, but for any court, and saying it was sufficiently crystal clear to that detective that he was not entitled to enter, that it was not reasonable for him to believe he could?
No, because Justice Marshall in his dissent suggests that if you make the wrong decision, you have to live with that. And there really is no precedent for him to look at in this case. So,
but every apparent authority is a wrong decision. You believe that this person had the ability to consent, and in fact they didn't. It was the girlfriend of Rodriguez. She wasn't living there. They reasonably thought she did. They reasonably thought when she said, "Come on in,"
but
she
the
had
difference
the authority. They're wrong.
But the difference in this case is that, let's go back to the Fitchburg case. If the school police said, which this issue wasn't raised, we thought the school, say it happened today, we thought the school had the authority, and they all say, well, none of us read the Nielsen case. I'm sorry I didn't know that. Certainly the court I suggest the court would not allow that to happen. And essentially in this case, because she was an executive director, not a co-tenant as all the other cases are, that he made the wrong decision. At some point, the exception's going to, take over the rule if we allow this in the future. And I ask you to sort of look at this and see what would happen in Nielsen had that issue been raised, which it wasn't raised.
Did Brown have an FID card?
She did not. I don't believe she did. That wasn't
Does
brought up.
that make a difference in this case?
Did Brown have an FID card?
Yeah.
You mean that the
To get the
executive
gun?
director?
Just
To get the gun.
I suggest that even under exigent circumstances, she could take that gun and bring it to the police, and she
Well.
wouldn't be at risk. But of criminal prosecution, if she would have called 911 right away and say that. But that wasn't addressed in the case.
Thank you, Mr. Corbin.
Thank you.
Cecilia?